coincided with the introduction by David Berry of the teaching of the Inter-American human rights system into his public international law course. And of course, in the most recent of times, both Ms. Robinson and Professor Rosemary Antwine were appointed to the Inter-American Commission on Human Rights, appointments which facilitate the cross-pollination of legal ideas and for which we congratulate them most warmly. If then we turn to undertake an honest examination of the Caribbean ambivalence towards the Inter-American system, we would confront the difficulties of integrating two legal systems that have different heritage, traditions, and sources of legitimacy. We would also confront the still emerging efforts to author a distinctly Caribbean jurisprudence, freed from subservience to colonial institutions, whilst being willing to accept modern legal norms and influences that are compatible with our constitutional arrangements. It is in this regard, as I have offered in a recent article in the West Indian Law Journal, that there are difficulties in reconciling aspects of the Inter-American Court's jurisprudence with the constitutional rule of law as traditionally understood in the West Indies. First, it is important to appreciate that the history and tradition of Caribbean respect for human rights and the guarantees of our Caribbean Bill of Rights sit uncomfortably with the motive for the adoption of the Inter-American system in the first place. It seems widely accepted that the Inter-American system was primarily designed to address massive human rights violations in Latin America after World War II. State-sponsored terrorism in the form of summary executions, torture, disappearances, kidnappings, and abuses of the right of freedom of expression were a common feature of the military regimes and civilian dictators in the non-democratic countries of the Americas. As Judge Thomas Bergenthal of the Inter-American Court puts it cryptically, quote, often the mere public discussion of human rights could land a person in jail or worse. Not surprisingly, the early litigation before the court concerned these very atrocities, the flagrant disregard of the human right of anyone the state considered subversives. By way of sharp contrast, these political problems for human rights were never characteristic of the Commonwealth Caribbean. To the contrary, these small English-speaking countries have had a profound and proud tradition of constitutional democracy, adherence to the rule of law, and respect for human rights. The breakdown in constitutional government, which occurred in the almost bloodless coup in Grenada in 1979, was not accompanied by reports of widespread breaches of human rights by the People's Revolutionary Government, either during their 4-year rule or upon return to the Westminster model of governance in 1983. Jamaica and Trinidad and Tobago have, on a few sporadic occasions, declared limited states of emergency and resultant suspension of some civil and political rights so as to deal with crime. But this has always been within constitutional limits and subject to review by constitutionally sanctioned tribunals. For these reasons, the Inter-American Convention and Inter-American Court were never engrafted into the Caribbean juridical culture. In the same way, I should say, that these institutions never became part of the legal systems in the United States and in Canada. Second, the history and respect for human rights, inherited from the British and enlarged by the inspiration of international human rights treaties, became enshrined in the Bill of Rights of the constitutions of the newly independent Caribbean states and jealously guarded by a fiercely independent judiciary. In the immediate post-independence era, Caribbean courts declared themselves to be the guardians of the Constitution and the guarantors of the human rights of the citizen. In a famous assertion of this role, Wooding C.J. said the following in the case of Colin Moore against Attorney General of Trinidad and Tobago, quote, "I am in no doubt that our Supreme Court has been constituted and is the guardian of the Constitution. So it is not only within its competence, but also its right and duty to make binding declarations if and whenever warranted, that an enactment passed by Parliament is ultra vires and therefore void and of no effect, because it abrogates, abridges, or infringes, or authorizes the abrogation, abridgment, or infringement of one or more of the rights and freedoms recognized and declared by the Constitution," end quote. As the ultimate interpreters of the Constitution and the rights and freedoms it enshrines, the Caribbean courts have found and punished violations of the Constitution by the executive, by the legislature, and by the courts themselves. In this way, the courts have not only reinforced their role as guardians of the Constitution, they have also emphasized the status of the Constitution as the supreme law of the land and the good norm of the domestic legal order. It is important to appreciate that in discharging its role as guardians of human rights, the Caribbean judiciary has not adopted a perspective that could in any way be described as insular, parochial, or nationalistic. Quite the opposite. Caribbean judges have accepted that the Bill of Rights were derived not merely from the common law heritage, but inspired by international human rights treaties and must therefore be interpreted in accordance with those treaties. For example, in Attorney General against Antigua Times, the court drew upon 1950 European Convention, on Human Rights in deciding that artificial persons could claim the protection of the Bill of Rights. Minister of Home Affairs against Fisher went against established assumptions of domestic law in holding that the word child in the Bermuda Constitution included illegitimate children of a Jamaican mother who had married a Bermudan. It was emphasized that the Constitution was to be interpreted on broad principles recognized in the protection of the family and the rights of the child, expressed in the United Nations Declaration on Human Rights, the European Convention on Human Rights, and decisions by the European Court of Human Rights, Universal Declaration of the Rights of the Child, and Article 24 of the International Covenant on Civil and Political Rights. Speaking for the court, Lord Wilberforce said that these antecedents called for a generous interpretation of the Constitution, avoiding what has been called the austerity of tabulated legalism. Similarly, decisions of international human rights bodies were accepted as aids in deciding on the issue of whether the mandatory death penalty was contrary to the constitutional prohibition against human and degrading treatment. In the landmark cases of Spence against the Queen and Hughes against the Queen, the Eastern Caribbean Court of Appeal studied and adopted findings in reports by the Inter-American Commission, which had found the mandatory death penalty to be unlawful because it prescribed individualized sentencing and did not take into account the personal culpability of the accused. Sir Dennis Byron, Chief Justice, as he then was, he's of course now President of the Caribbean Court of Justice, expressly relied on the jurisprudence developed in the Inter-American system. In similar vein, the Supreme Court of Belize upheld traditional land title rights of indigenous Mayan communities in the case of Cal against Attorney General of Belize. This was partly because the Inter-American Commission had earlier made relevant findings for the Mayas based upon Belizean obligations to indigenous peoples under the OAS Charter. According to the Chief Justice, Inter-American norms resonated with certain provisions of the Belize Constitution. To similar effect, the CCJ, in the case of Trinidad Cement Limited and Guyana, referred to and relied upon the decision of the Inter-American Court in Velasquez Rodriguez to come to the conclusion that punitive damages could be awarded against the state in international proceedings in certain circumstances. Albeit in the Trinidad Cement case, the CCJ held that such an award would not be appropriate on the facts of that case. It will therefore be obvious that Caribbean courts have freely drawn on the Inter-American system and other human rights regimes in order to enrich the rights enjoyed under the Caribbean Bill of Rights. Indeed, in specific instances, the executive has mandated that the judiciary consider international human rights treaties in adjudication coming before them. See, for example, the Constitution of Guyana. The critical point remains that the statement of human rights in Caribbean constitutions and the willingness of Caribbean courts to consider and apply international human rights norms in the interpretation of those rights has provided significant protection to the Caribbean people. That openness of mind in our judiciaries is buttressed by the rules of eligibility of the Caribbean Court of Justice, which allows for jurists trained not only in the common law but also in the civil law to be appointed justices on that court. Indeed, one civil lawyer has been appointed and now serves on the bench of the CCJ. Caribbean jurists have served on several global human rights tribunals, often as the president of those tribunals. A case in point being Sir Dennis Barron, the current CCJ president, who is at this moment as we speak terminating a distinguished stint as president of the United Nations International Crime Tribunal for Rwanda. Notwithstanding the open-textured nature of Caribbean jurisprudence, one principle is held sacrosanct. It is a principle of constitutional supremacy. The bedrock principle is that the Constitution is the supreme law and is the source of legitimacy of all other laws affecting the individual within our jurisdictions. The rule of law is maintained by the subjection of the executive, the legislature, and the judiciary to the supremacy of the Constitution. It is that rule of law which has undergirded over 300 years of almost unbroken representative democracy, respect for human rights, and the orderly evolution and development of the Caribbean society. Caribbean constitutional supremacy binds us and defines us, and it is the basis upon which we proffer a distinctive jurisprudence to the world. However, it is with this sacrosanct principle of Caribbean constitutional supremacy that recent decisions of the Inter-American Court seem to come into conflict. Sir Dennis in Spence and Hughes had hinted that the Eastern Caribbean Supreme Court did not accept that human rights agreements, such as the American Convention, could override clear statements in domestic law or the Constitution of sovereign independent Caribbean states. But in Boys and Joseph against Barbados and Cadogan against Barbados, the Inter-American Court, in conformity with its statute, has taken a dramatically different approach. In both cases, the court ruled that aspects of the laws and constitution of Barbados were contrary to the right to life as provided in the Inter-American Convention, and ordered Barbados to amend both in order to come into conformity with its international obligations. In short, the Barbados Constitution was considered subservient to the American Convention. have elsewhere pointed to the juridical as well as visceral difficulties to which this gives rise. A related difficulty concerns the order by the Inter-American Court to the executive to ensure amendment of the laws and constitution. Under our system of separation of powers, an order to the executive as representative of a state in foreign affairs cannot bind our parliament, which enjoys primacy in lawmaking. To illustrate, the government would encounter real difficulty in complying with the order where it does not command the necessary parliamentary majority to alter entrenched or deeply entrenched provisions in the Constitution. Even greater difficulty would be encountered if modification of the impugned provisions in the Convention required an affirmative vote in a referendum, or worse still, a special majority vote in that referendum. The Inter-American Court's view of the role of the Caribbean judiciary is also difficult to reconcile with the traditional view of our judges being the guardians of our constitutions. In Boyce and Joseph, the Inter-American Court chided the Privy Council for finding that the Offenses Against the Person Act was protected by the Savings Law Clause in the Constitution. In its view, the Privy Council conducted too narrow an examination of the validity of the Act. The analysis should have not been limited to the issue of whether the Act was constitutional. Rather, the question should also have been whether it was conventional, whether it was consistent with the American Convention in the view of the Inter-American Court. In the view of the Inter-American Court, Barbadian courts, including Privy Council and now the CCJ, must address not merely the matter of the constitutionality of the law, but also whether the law restricts or violates rights recognized in the American Convention. I do not recall any discussion of the juridical basis upon which the highest court could properly undertake this task, where the Inter-American Convention, though ratified, has not been incorporated into domestic law. In other cases, the Inter-American system has ordered new trials in circumstances where the highest domestic court has pronounced that the trial at first instance had been fair, and the Court of Appeal had not erred in dismissing the appeal from conviction or sentence. Although the Inter-American Court probably considers that it is competent to issue such an order, which is to be obeyed by the state, the fact of the matter is that an order to the executive does not necessarily translate into an order to our judiciary, given the constitutional doctrine of separation of powers. I skip over a couple of paragraphs in light of the yellow, perhaps red flags which have been sent my way. There is another sense in which the work of the Inter-American system raises questions of constitutional governance. It is the perception, whether held rightly or otherwise, that inter-American systems sometimes function to frustrate the carrying out of legitimate sentences of the court and thus undermine the rule of law. We are, of course, here speaking of the sentence of death. In the words of Lords Gough and Hobhouse, dissenting in Thomas and Hilaire, the Inter-American Commission espoused a policy of discouraging capital punishment wherever possible, and in accordance with that policy, appeared to see postponement of an execution for as long as possible as an advantage, since it may improve the chances of commuting the sentence or quashing the conviction. There is thus a direct conflict between the policy of the Commission and the enforcement of the law, end quote. Statement from the Privy Council. It will be recalled that this alleged procrastination in the hearing of petitions so as to ensure the Pratt and Morgan 5-year window for executions is closed and death sentences commuted was the principal reason for Trinidad and Tobago to withdraw in 1998. As Chief Justice Conte of Belize has said, insofar as the death penalty is part and parcel of the penal armory of the states concerned, and the right of a condemned person to petition international human rights bodies as has been upheld by the Privy Council, I think it is only salutary that the Inter-American Commission on Human Rights proceed with dispatch to hear and determine petitions submitted to it." End quote. Permit me to close as I began. Caribbean courts consider seriously and respectfully the persuasive value of the recommendations of the Inter-American Commission and the rulings of the Inter-American Court. We are open to the possibilities for evaluating and accepting, where appropriate, regional and global human rights norms into Caribbean jurisprudence, thereby enhancing and enriching the language and culture of Caribbean human rights discourse. For similar reasons, it seems to be both permissible and desirable to draw upon decisions of other regional and global human rights bodies, as well as decisions of Supreme Courts which grapple with these issues. The marketplace of ideas, which is accessed through international comparative human rights law, provides an excellent opportunity to identify best practices and the most appropriate solution to specific problems coming before Caribbean courts. Indeed, as I've pointed out already, at least one Caribbean constitution requires the court to have due regard to these international human rights conventions. But judicial comity cannot permit subjugation of our legal traditions and systems of governance to other systems of law. This for the simple reason that Caribbean courts are creatures of the Caribbean constitutions, and Caribbean judges are sworn to uphold the constitutional rule of law. I hope that we can find a way to make the Caribbean legal system and the Inter-American system not contradictory but complementary, so that our two traditions can contribute to and enrich each other. Thank you very much.
Thank you, Justice Anderson. A great deal of food for thought. Some of the chewing will get stuck in some throats. But the next speaker, I'm sure, will deal with some of the issues in Justice Anderson's paper, and I hope we will have time for a few questions for discussion. Our next speaker is Judge Diego Garcia Sayan. He is the president of the court. I beg your pardon? Oh, he's the president of the Inter-American Court. And Judge Garcia Sayan is an attorney at law. He was at one time foreign minister of his country of Peru. He has been the president of the court for the last couple of years. I forget. And he is a hard taskmaster, and he has been engaged in human rights work for many, many years in the region, and has traveled widely, not only in this part of the world, but in Africa and so on, negotiating agreements and taking part in conferences, seminars, and so on. His experience is extensive. We're lucky to have him as president. So it is my pleasure and my honor to call our president to the podium. Please welcome him to the podium.
Good morning, morning, distinguished members of the panel, distinguished authorities, dear friends. For me, it's a real honor to be here with you. Maybe you will be a little bit tired now at the end of this lengthy morning, so I will try to be very precise, direct, and, if possible, Margaret, brief. When 40 years ago the American Convention was voted and signed by most Latin American and Caribbean countries in 1969, that convention included the creation of a court which, after what was decided with sovereign decisions by the countries, not imposed by anybody, a court with the possibility to take binding decisions. At that moment, I was still a law school student and later a young lawyer, and the first law professor to teach the course of human rights in the university in Lima. And when we spoke about the American Convention and about the Inter-American Court back in the 70s, all that had the sound of a big utopia. When and how these countries of the Americas will accept really a court with the possibility to have binding decisions, and then if they will implement at all the decisions of that Inter-American Court. And in those years, of course, I was promoting training courses with judges, not only in Peru, but in the other Andean countries. And the reaction of the judges, the national judges, was quite different than the ones we have right now. They say, what we should do with that foreign legislation? With that, if that court, Inter-American Court, eventually that will exist, that will be a foreign court. We have our own courts, we have our own constitution. What have we to do with that strange and foreign legislation? So, after 40 years, many things have changed, many things are changing, and I am sure many things will continue to change in the Americas. A month ago, we were holding public hearings like this one in Barbados, in Colombia. And we have a seminar like this, in a big gathering, several hundred people were there. And while the people were sitting and accommodating, it was very difficult, a lot of people, we were in the same panel with the president of the Constitutional Court of Colombia. We have turned to be very close friends after these years of dialogue between systems, between international system and national system. So while we began, I asked him about a case which is very public in Colombia, and the only question was nothing to do with internal matters, but when are you going to decide that case? And he answered me, why? Because we want to know what are you going to decide in that case. So he answered, you want to know because you have other case, which is also public, that you want, you are going to decide in the following weeks. I have read in the newspaper, he said to me. Well, but you don't answer me. Finally, when are you going to decide in the Constitutional Court? No, we are waiting that you decide before. And I answered him in a joke, well, we were waiting exactly the same for you, that you decide before. So this kind of private-public dialogue, in a way, illustrates the stage in which we are now. A stage in which there is no system, foreign system, quote unquote, that imposes its decision, or national courts that accept and receive this imposition, but an immense and creative dialogue between national courts and this Inter-American Court, in which this utopic dream of the 70s is no longer a utopic dream, but part of the new judicial and juridical culture in the Americas, of course, in part of a very difficult process. The court, Inter-American Court, right now is alive, is strong. The number of cases is increasing. In the last 5 years, the court has decided the same amount of cases that it decided in all its history since the beginning. And the court, of course, number of cases is increasing not because the human rights violations are increasing in the Americas, but because the awareness of the public that the court exists, that the system is available, is getting stronger and is increasing. And of course, the court had at the beginning most cases coming from massive and atrocious human rights violations. Not because, of course, the convention is oriented to that problems, the convention is oriented to human rights violation as a whole, but because that was reality that came from many Latin American countries during the 70s, after the convention was drafted and adopted by the way. No? So the situation has changed to a point in which you may all have seen the case with which we dealt yesterday, which has nothing to do with massive human rights violation, but with specific violation, allegation of violation, in a context in which in most countries of the Americas, fortunately, we have constitutional, democratic, elected regimes. So in this context, we are increasingly similar in all the Americas. This division among countries that have a constitution and others that don't have or don't respect the constitution is eroded. And right now, we have a context in which, with different legal systems, of course, we have increasingly more similarities than before. So but the first question I want to stress was that decisions of the Inter-American Court are applied and are implemented by the countries that are supposed to follow a binding decision taken by the Inter-American Court. That's a fact which is very important, that in a way has give a different approach, a different image than what many people expected 50 years ago or 40 years ago. More than 80% of orders of indemnification are paid properly by the states concerned. When the court decides, not because it has an authoritarian or arbitrary approach, but because that was the convention says, that laws and internal institutions should be adapted to the obligations of the convention. When the legal binding decisions of the Inter-American Court orient things in that direction, that has led to legal modifications in several cases, leading, for instance, to repeal the provisions by which civilians could be prosecuted in military courts, to amend the constitutional provision in the Chilean constitution that authorize previous censorship to public shows, and many other things that have to do with the improvement of due process and of judicial guarantees. So the first important fact is, and that was mentioned as well by Judge Ventura Robles, is that the decisions of the court are implemented. And when there is not immediate implementation, there is a positive dialogue, so to do so, as it is the one being held with Barbados in the two cases that have been decided regarding this very friendly country. Second, what maybe seems much more important than this, because if you see the figures about the number of cases we have, careless if we have or haven't we have increased the number of decisions in the last years, that number is very small. If you bear in mind the huge area we are covering, and that more than 500 million people are living in countries that have accepted the jurisdiction of the Inter-American Court. So if we would thought that the Inter-American Court will be the court to solve all problems of human rights, that would be absolutely ridiculous. That won't work. We will need all the budget of the European Union to work, and we know that we won't receive all the budget of anything, which will be more or less important. No? So what is really crucial, and it has immense historical relevance, is that increasingly national tribunals are using the criteria and the jurisprudence of the Inter-American Court to take its own decisions. And that is leading to one of the most positive steps that have been occurring in the institutional and political evolution and juridical evolution in the Americas in the last years, in the sense that this strengthening of an Inter-American Court at the same time is working as a source of strengthening of national institutions and mainly national judicial institutions. If you follow what important high courts, all of them are important, but important for the consistency in their jurisprudence in this area, have been deciding in this matter in the last decade, is quite impressive. For instance, the Constitutional Court of Colombia, which has been very relevant to create this process of interaction and of dialogue between national system and the Inter-American system, is using permanently the jurisprudence of the Inter-American Court as the main interpretative criteria, so to take its own decisions. And of course, the Constitutional Court of Colombia is dealing with not dozens, but hundreds or thousands of cases that the Inter-American Court won't ever be able to deal with, no? And with a creative approach in which they don't limit themselves to copy what the Inter-American Court is saying, but they include a creative approach, which is very important. The Peruvian Constitutional Tribunal, after a process in which, of course, Peru had an authoritarian regime during the 90s, has decided that all national authorities are obliged by the jurisprudence of the Inter-American Court, careless if Peru has been or not matter of the cases decided by the Inter-American Court, and it is being implemented as so. In the last weeks, the biggest Spanish-speaking country in the world, which is not Spain, it is Mexico, has decided, its Supreme Court, with a sovereign decision, has decided that to improve the situation of human rights in a context of terrible violence that you can see easily through news daily, to improve the situation, not only the provisions of the American Convention should be implemented, but the decisions of the American Court, and the most important thing, that so-called in Spanish, control de convencionalidad, that the judges should be, since this week, obliged to use the decisions of the Inter-American Court of Human Rights in the text of the American Convention as a criteria, so that their own decisions adapt to that international obligation. So the way through which national institutions are responding to these big critical situations of violence or crime is not responding with authoritarian or dictatorship approach, but with strengthening their own national institutions. So in this sense, I want to raise this very crucial matter through which this traditional approach, through which there are two legal systems, our national system and the international system, has been eroded not anymore by an academic debate, by what has been happening in practice, through which at this stage the new culture of the juridical level that is prevailing in the Americas, is beginning to prevail, I would better say, is to say, well, we have this, our national system, of course, every country has its own national system, which is crucial and key, but we at the same time, after a sovereign decision, we are part of the world, and we have decided to follow certain agreements, not only trade agreements, but of course, agreements that have to do with rights. And if these rights turn to be that we are not renouncing to our sovereignty, but strengthening a positive dialogue through which the criteria that we found that are positive, so improve our national situation, that are being used right now increasingly by national courts, and that's very important. Two or three very small things so to finish. First, when countries have taken this, move on with this process, in all of the cases, without exception, that has been after major decisions taken by the high courts, not after decisions taken by lower judges, which are usually reluctant to make big innovations like this because they should follow certain jurisprudential criteria, careless if it is common law or civil law, it's exactly the same for this aspect. Second, it is not question of imposition. It is question to capture the experience of what can be used from international areas so to strengthen our national capacities. And thirdly, the result right now with the countries that are following this step is that they have now stronger judiciaries, stronger national institutions, so that people know that eventually they could present their own claims if they have the feeling that they are victims of a human rights violation to the national courts with some possibility of success that previously was scarce. No? So, to end, really, I should insist that we are in the middle of a process, no? We have not arrived yet, and we will never arrive finally, of the creation of a new juridical culture in which the traditional barriers, the traditional borders are being diluted, not because somebody has decided so, but because that is the process that societies are generated. And that regarding specifically the weakness that the Inter-American Court has, not only budgetary weaknesses, but the weakness that not all countries of the Americas have at this stage accepted the jurisdiction of the Inter-American Court. Of course, that's objectively, that is a weakness we do have. I have the, not only the feeling, but I am absolutely sure, but we are, as this meeting, this possibility that we have received here, the hospitality of the authorities of Barbados and the people of Barbados, we are in the appropriate direction. We are in the move to promote and to take this dialogue, and as the Chief Justice said at the beginning of the morning, this is a very important step, a very important first step that from the Inter-American Court we will look forward to follow with many, many, many other steps to the future with optimism that we are creating really a new culture and a new juridical system so to protect and improve the situation of human rights. Thank you very much.
Thank you very much. We are at the end of the presentations, and if I may make one comment related to Justice Anderson's presentation, which maybe will start the ball rolling. Dean, we do have time for a few questions, do we not? Thank you. And this is, I subscribe to the view that we come from a very strong and good system of constitutional law, being in the common law system. I don't speak about the system of my brothers and sisters in the court, the civil system. Our system has the tradition of constitutional respect. The respect for the Constitution, the application for the Constitution. We got this from Britain. But it is interesting to note that of all the countries in Europe, Britain had the largest number of cases of violations of human rights in the European Court. It is not that countries do not respect the constitutional rights of the citizens, why we need international court. They do, but they cannot do everything. And we do have the weaknesses of the national courts failing its citizens too often. We practitioners know this, and we cannot pretend that it is otherwise. So the need for a complementary system to protect our human rights cannot be gainsaid, with all due respect to Justice Anderson. He has given us the basis of an interesting discussion, and I think we can move on to that. Another matter, I think it's 6 countries which have ratified the convention in the Caribbean, so half the number. We hope it will be much more in the very near future, especially following this session here. So, let me not ramble on. I can go on forever if you let me on this issue. Let me now open the floor to questions, statements, comments. Please. Lovely. Hello, Rosemary, by the way. It's good to see you.
And I don't think the point is that we don't want to have better norms and so on with international human rights norms. I think the point is, which I agree with, is that far from the Constitution being a tradition, as you described it, the Constitution is extremely.
It is, yes.
We don't want to adopt, but we must find a different mechanism because we are fundamentally to the civil law legal tradition. It is indeed a dilemma for Caribbean jurists and academics. So I don't know, I will have to go with Justice Anderson on this point. And I think perhaps in the round table this afternoon we can discuss.
Oh yes, yeah.
And some of the ways we can reach there, because what I heard Justice Anderson say is a hope that we can find a ground that is complementary, not that we wish to be antagonistic, but we meaning those of us who must subscribe to the Constitution. Because I don't think it's as opposed to us as the law brothers and sisters that say or pretend that the Constitution is subservient, because that seems to be that where it would take us if we were to. And I agree with you that England may have a lot of constitutional law violations, but don't forget we are all different from the UK. We have a written constitution. So I don't think that we can compare ourselves easily with the United Kingdom. So we do have a real dilemma. It's one that I have on my law legal system hat and my human rights hat. I've long analyzed over. But as I said, perhaps this afternoon, because I think we're going to see it
That your agony would cease.
we can discuss it a bit more. I think it does need to be discussed.
Oh, it does. We need to discuss it in great detail. But I'm sorry. I do not believe I misunderstood the position. And our constitution are the organic law, as our sisters and brothers in Latin America have. Their constitutions are the same. They hold the same position in their legal system. So there's no difference in that. And the fact of the matter is we are a complementary system in the Inter-American system. We apply the convention. We do not seek to apply the national constitutions, nor national laws. We can only apply our law, which is the convention. And the states and state parties subscribing to that convention agree to abide by the principles enunciated in that convention. And I don't think that our bills of rights in our constitutions, with all the provisos, are as wide in their protection as the convention can be, or an international instrument can be. But as I say, we can't speak further. Please, let me not take it over. Yes.
Thank you. Let me start by saying it's all very interesting to me. I'm no judge, I'm nobody in legislation, I'm a doctor and I'm the Speaker of Parliament. But on behalf of the people of my country, we are very interested in this. Because yes, in our constitution it is written that if we are part to a treaty, if we have ratified it as a parliament, yes, then it will be higher than our constitution. It is written in the constitution, so no problem there. We only have to make sure that we go for the right conventions and treaties. So yes, sorry, you're right. I'm Jennifer Simmons, Speaker of the House, Suriname. I'm here with the delegation of the Human Rights Committee of the Parliament. I wondered, and I thank Dr. Dr. Diego Garcia for his suggestion that we improve our national systems so that we ourselves, because of course, we have in our country the same thing. Okay, we have a constitution, we have a judicial system, and we want to be sovereign. Okay, and on the other hand, we have decided that we would respect a Convention of Human Rights and so on and so on. And we also see in our country at least, and I will say that we have had problems in Suriname. We were maybe not so lucky. We are not too different from the rest of South America, but maybe not so lucky as the Caribbean. After independence, and also before independence, because I don't know what I heard, but it seems like the English had no slavery here, violating human rights, but the Dutch had. And so we don't think that we have 300 years of human rights respect in our country. So we started after independence, and we also had our problems. But it is not only those excesses that can ruin people's lives. We had an example yesterday, and there are in my country, I know. We don't have enough judges. We have a slow system which can ruin people's lives, and if the country doesn't respond, then the people have to find a way to some other solution, and this is what we, of course, have agreed with one another. So I also think that we should keep the people home. I say it in layman's terms, I keep the people home. I don't want my people to go to the court. So if I don't want that, what I need to do is strengthen the local system in accordance to what we have agreed to, which is what are human rights. And not only when you kill people, you violate human rights. Also when they apply, for example, when they have a punishment, some punishment, they appeal, it takes too long, and so on and so on. So, and these things can ruin people's life. It doesn't have to kill them. Maybe it kills them because of high blood pressure, you will know. So, I'm very serious here, and I'm very glad that I came. And to conclude, Suriname has two problems in this. We also are in the Caribbean Court of Justice. I was no part of that decision, but we have a very different system from the English system, and we know that. And we are part of the Inter-American Court. So I go home with some serious questions as how do we combine the three systems. We have the Dutch system at home, we are part of the Caribbean, and we also ratified something about the Caribbean Court of Justice. So, and we are part of the Inter-American Court of Justice. Okay, maybe sometimes enough is enough. So I'm going home with questions, but I will thank all of you. And because I think I learned a lot, and we are in the process of strengthening our local system. And I think that we will need the support of our regional community, and not Suriname only, I guess all of us, I think we all have problems if we want to acknowledge it. Thank you.
Thank you so much, Madam Speaker. Juliet.
Thank you very much. Madam Chair, I'll be very brief.
Name and country.
I can,
and
Hugh Rollins, Chief Justice, Eastern Caribbean Supreme Court.
There we are.
May I begin very quickly by saying that I think Chief Justice Gibson would have been very happy to be here to hear these presentations this morning, because it would prove that he is quite correct, that Max Weber was correct, and we are moving to that happy state of equilibrium. It might take time, but I have no doubt from these presentations that we'll get there. Dr. Gomez, I was struck by the way you started by indicating that you are not a justice, that you do not have justice. It reminded me of an after-dinner thought that was thrown out by someone not too long ago, and that was, you know, perhaps if judges did not have justice before their names, you wouldn't know it. I thought it was quite cheeky. And I looked for the expressions, and you could see the changing expressions. On the one hand, by those who thought that was quite wise and correct, and on the other hand, by those who thought that that bordered on being rude. I thought it was a good after-dinner joke. To say, Dr. Gomez, the justice is not necessarily in the title. The justice is in the work that is done. And the work that you have done, obviously, is one that is so fundamental and striking that it is to be commended very highly. And of course, the stimulation that has been brought by these presentations, I'm sure there's so many questions in our minds. Not only that, we are going to debate the questions relating to which has primacy, international or constitutional, but I think that is quite going out, and Dr. Anderson, Justice Anderson, I think in his conclusion, the conclusion of his paper, got it very correctly. It's a question of us seeing what is best that we can assimilate from one institution to another. And I think it has been pointed out by all of the speakers that that is where we're actually going. And just another question, Madam Chair. When you indicated that in the United Kingdom, they have perhaps the most cases going to the European Court of Human Rights, I just wondered whether that might have been because they're more recalcitrant, or whether because over the years, based on the jurisprudence and the respect for the court and constitutional matters in the United Kingdom, their society perhaps is one of the best prepared, and where persons are not minded to be slow to take any hint of violation to the tribunals of the land. That's also a possibility. But I am so happy that we are here this morning and today for these discussions, so stimulating. Let me not go any further, but to thank everyone.
Thank you very much, Chief Justice. Anyone else? Oh, yeah? I didn't hear that. Oh, but it will be good if you say it now. Huh? Can you, please? then you could expand more later.
May I say something?
Yeah. Yes. Justice Perez is just going to say something.
Thank you very much. I think we all have to take into account what it means to ratify a treaty. It means to be bound by the obligations created by that treaty.
Mhm.
So I think some of the problems that were put before us may be solved if we follow another suggestion such as justice before the name and all that, which is think first, ratify later. Once you have ratified, you're bound. And if you haven't read the treaty, it's well, something that happens to everyone who doesn't read a contract when they have the time to do it. And just the final thought on my part is to remind everyone here that the first case decided by the European Court of Justice was brought by a person, or in the name of a person, called Lawless. He was doomed in advance.
Thank you very much. Thank you very much, Alberto. Yes,
It
please.
was against Britain.
I just wanted to,
Name and
sorry, Gregory Nichols, I'm an attorney at law and tutor of human rights and admin law in the faculty here. I just want to ask Justice Anderson, given the position taken by the CCJ in the Joseph and Boyce case, which was before his time there, whether or not the doctrine of legitimate expectation kinds of causes the notion of municipal and international law to disappear. Because it seems to me that there could be a case that, given the court's position on legitimate expectation as a kind of circuitous way to protect the human rights of the individual, could hold that Barbados' treaty compliant behavior under the Inter-American Convention behoves the state to comply with its international obligations, and therefore the state should not act to defeat the legitimate expectation of its citizen. And that is given the basis of the CCJ's decision. So therefore, whether or not the CCJ's decision in upholding the legitimate expectation of the citizen does that not complicate the issue which you sought to put so clearly this morning?
Justice Anderson.
I thought I'd said it all. And I will say that I hope to have the paper. Are you hearing me? I hope to have the paper available for those of you who wish to have a look at it. The question raised by the former senator is a very interesting one, of course. And indeed, on the bench of that case, one judge went further than legitimate expectation, as you might recall. Justice Witt suggested that once you have signed on to the treaty, it becomes a part of domestic law, even without having to get into legitimate expectation. Because once you do, of course, that expectation can be defeated by the actions of a government, for example. It's very easy to defeat legitimate expectation, government simply making the appropriate statements. But even Justice Witt acknowledged that the incorporation of international treaties into domestic law was subject to two sources of law: legislation by our parliament and the Constitution. So I don't see any difficulty whatsoever. I don't speak, of course, for the bench here and now, but it would seem to me that the doctrine of legitimate expectation and the rights it allows to be incorporated into our system, so the rules must always be governed by our Constitution. I don't see that we can suggest that any other system of law is superior to our Constitution. That would be a heresy in this place above all other places, the faculty of law, where our founding fathers established Caribbean jurisprudence. And whilst I'm on the floor, could I just make one or two other comments? My brother Judge indicated a few minutes ago that we must be very careful about when we ratify treaties and conventions. I entirely agree with him. And of course, that is why Trinidad and Tobago, having ratified the convention, withdrew because it thought that the activities being taken under that convention infringed fundamental rules in the Trinidadian system. I also think, of course, that that's the very purpose why we're here now, so that we can have a full and frank discussion of the implications of ratifying the convention, so that if we do decide to ratify the convention, we go in with our eyes wide open and we know what we're getting ourselves into. I also want to speak very briefly to what the esteemed president of the Inter-American Court said about the ways forward. And one way, of course, is the suggestion that there is an erosion between sovereignty and international law, international systems. And again, that may or may not be the case, but as I said, you know, we are judges of the courts in the Caribbean. We are bound by our constitution to operate in a particular way. And until our constitutions are amended or changed in the proper way, we can do nothing other than abide by the dictates of our constitutions. Now, I'm not saying, of course, and I try to say in the paper, that we will be parochial or nationalistic or insular. I have indicated with multiple examples that we're willing to consider the jurisprudence coming out of the Inter-American system, the Inter-American Commission on Human Rights, the Inter-American Court of Human Rights, and indeed, of course, the European Court of Human Rights and other international bodies. But the question, I think, and we must not hide from the question, we must face the question frontally, is whether we allow another legal instrument, to wit, the Inter-American Convention, to be superior to our Constitution. That is the fundamental point. And I want you to bear in mind that it's not simply a matter of words. It's not a matter of an academic debate. As I suggested to you, there are real difficulty in our systems of governance in terms of the function of our parliament, in terms of the function of our courts. And if we're going to go that route, again, I think consequential changes will have to be made in our legal systems. Very briefly, Suriname, I was not suggesting that we had over 300 years of unbroken respect for human rights. What I thought I said, and what I tried to say, is that we had over 300 years of unbroken respect for representative democracy. And I think if you spoke with the persons here in Barbados, they'll tell you that the Barbadian Parliament, I think, goes back for over 350 years. Finally, I did say that there were 4 Caribbean countries which had accepted the Inter-American Convention. I was speaking, of course, Madam Chairman, about the Commonwealth Caribbean, and that was the brunt of my remarks. I accept, of course, that both Haiti and Suriname have also accepted the convention. Thank you very much.
Thank you. It is both my pleasure and my sadness to bring this, unfortunately, to an end. I know we're going to continue this discussion later this afternoon. But if I may thank all the speakers for the richness of their presentations, and also to you for being here, for listening so avidly, and to those who have contributed and participated. I also wish to personally thank the government and state of Barbados and the Faculty of Law and the University of UWI for hosting this session today. I will say this, that the Chief Justice said this morning that he hoped that people would return to Barbados and visit Barbados after those who have been here for the first time. I am sure they will. They all love the beaches and so on, but they do not love the prices of your food. Thank you so much, everyone.
Excuse me, everyone. Excuse me, please. We're going to have a coffee break.